Hello friends, in the present case which we are going to discuss today, that case is related to the digital evidence which is collected by the revenue at the time of search or surveys. So the question before the Madras High Court in the present case was that whether the manual which has been issued by the Central Board of Direct Taxes under section 119, and that manual is Digital Evidence Investigation Manual and Regulations. The question was that whether this manual has the statutory force under section 119. In the present case, the court said that the revenue collected 61,948 digital files. Out of that, only 8,993 files were readable and the rest were corrupted, and the assessment was done on the basis of only those files. So in the present case, that is SARAVANA Selvarathnam Retails Private Limited versus Commissioner of Income Tax, which is reported in 463 ITR at page number 523, and the date of the judgment is 23rd February 2024. The court said that the manual has a statutory force and whatever the evidences have been collected by the revenue, that should be preserved and kept and used in according to the guidelines of the manual which has been issued in 2015. The court said that when the number of the files was so huge, that was near about 61,000 and at the time of assessment only 9,000 files were readable, it means that the manual was not followed to preserve the files. So in that case, the whole process of assessment comes into question, that how that digital evidence has been used. The court said that in the present scenario, even a layman in a country is expected to file his return of income in a online manner, and even all the assessments are done in a faceless manner, and even the ledgers are now in the digital form. So the importance of digital evidence investigation manual becomes more important because the whole income tax department has been computerized. Apart from that, the court said that whenever there is some technicality in any writ, then in that case the courts should not dismiss the writ on the basis of technicalities, and they can mold the writ to give the relief and the much desired relief to the assessee. And the court said that if the digital evidence manual, the provisions of the act are not followed in respect of the digital evidence, then it can be safely said that the writ of the assessee should be admitted and it should not be dismissed only because of the ground that the alternative remedy is available. In the present case, the court also emphasized on the importance of cross-examination and said that if any statement is relied on during the assessment proceedings, and if the assessee demands for the cross-examination of the person on the basis of whom the additions are being made, then it is an inherent right of the assessee to claim the cross-examination of that person. The court also emphasized the importance of witnesses which have been which are taken by the revenue at the time of recording of the statement under the such provisions. Those provisions says that the witness should be from the same locality, but in the present case, one of the witness was the GST officer who was also involved in some GST search on the assessee. So as far as the credibility of that witness is concerned, that is not established in the present case. So on the basis of the facts and circumstances of the case, the court said that in the present case the assessment proceedings should be quashed and all the proceedings should be given a new look, and the assessee should be given the opportunity of being heard according to the Digital Evidence Investigation Manual and Regulations 2015. At the end of this video, once again I am repeating the name of the case. The name of the case is Selvarathnam Retails Private Limited versus Commissioner of Income Tax Appeals and others, and this case has been reported in 463 ITR at page number 523, and the date of the judgment is 23rd February 2024. Thank you, friends.